You've built something valuable. It might be a piece of software, a unique design, or a comprehensive manuscript. And now, a company wants to take it to market and exploit it commercially. This commercialization phase is a critical juncture. Many creators sign standard, boilerplate contracts without realizing that copyright law is built on rigid, specific definitions that dictate the future of their work. To transfer your rights, you stand at a strict legal crossroads. You are forced to choose between two very different paths: assigning your rights or licensing them. The easiest way to understand the difference is through the lens of property. Assignment is the permanent sale of the asset, while licensing is a temporary rental agreement. Selecting the wrong path at this stage can result in the unintentional loss of the entire future value of your creation. Let's look at the first path: assignment, or cession under Belgian law. This is the definitive sale of specific intellectual property rights. The immediate consequence here is a total transfer of ownership. You are completely divested of the rights you choose to sell, and the buyer becomes the new legal owner with no path for you to reclaim those rights later. Because this sale is so permanent, the law applies a safeguard called strict interpretation. This means you only sell exactly what is explicitly written on the page. If the contract lists the right to reproduce and distribute, those are the only rights the buyer acquires. Belgian law adds another layer of protection. There is an absolute legal ban on transferring rights for technologies or modes of exploitation that do not yet exist at the time of signing. Any clause attempting to claim these unknown future uses is automatically null and void. Assignment is an effective tool for those seeking an exit, but it requires hyper-specific boundaries in the contract to prevent a creator from losing control over more than they intended. This brings us to the second path: licensing or concession. This is the rental agreement. You grant someone else permission to use your work for a time, but you remain the legal owner. Licensing allows you to dictate the terms of use with precision. You can set strict time limits, restrict usage to specific geographic territories, and define the exact scope of how the work can be exploited. The primary safety net of a license is its expiration. Once the agreed term ends, all usage rights automatically revert back to you. This retention of ownership is the foundation of a common strategy in the Belgian business landscape, the director-creator model. This is where a founder licenses their own intellectual property to their own company. This setup allows the founder to maintain personal ownership of their creation while securing a recurring stream of income. Meanwhile, the company gains the legal authorization it needs to exploit the work and generate revenue. Under a license, intellectual property functions as a dynamic, long-term asset that the creator continues to manage over time. When you stand at this legal crossroads, your choice dictates your degree of control, the duration of your commitment, the reversibility of the deal, and how your income is classified. These legal definitions are the specific criteria the Belgian tax office uses to determine your tax rate. If a contract correctly establishes an assignment or a license, the revenue can be taxed as a royalty at a flat 15% rate, significantly lower than the tax brackets applied to standard professional income. While both paths offer this fiscal advantage, the mechanics of how that tax is calculated depend entirely on which of these two legal routes you select. Making the right choice is a matter of aligning the legal mechanism with your objective, whether that is walking away from the property entirely or maintaining your status as the owner. Please note, the information provided in this video is for educational and informational purposes only and does not constitute legal or tax advice. Always consult with a qualified professional before making contractual decisions.